Good afternoon, everyone. We'll get started in just a few seconds just to allow everyone to get set up. Okay, so thank you for joining us in what is the final of our four-part Tuesday webinar series related to the Title IX regulations. Today's program is going to focus on how the updated regulations have impacted employment issues. For those of you who have been following the last few weeks, my name is Christina Riggs. I am the vice chair of our firm's higher education practice group. Weeks ago, I kicked off this series talking about what falls inside these regulations, either by definition or by jurisdiction, and went through a dive and understanding of what you can and should be doing with conduct that falls outside. Following that, I moderated two panels with our colleagues Jim Keller and Josh Richards, who walked us through an advanced dive of how reporting and investigations have changed, and then just last week, how to really handle this from a grievance procedure process, most notably the new inclusion of the live hearing requirement. But we thought that it would be very important to take a step back, having walked through all of that lead up the last 3 weeks, and really take a different spin, or perhaps a more focused spin, on the regulations and how each of those additional concepts that we've talked about really can and should be tackled from the employment side of the house, as we recognize there may be some nuances there. So today's presenter is our colleague, Jim Taylor, who is one of our co-chairs of the Higher Education Practice Group and also works with a series of K-12 schools throughout the country. You are in great hands today with Jim. In addition to handling a variety of issues for colleges and universities, he also has a very flourishing labor and employment practice. Just last year, he took 2 employment-related discrimination cases for colleges and universities to verdict, both successful verdicts. And so he truly understands not only the theory behind these, but the practical implication of some of these issues. Before I turn it over to Jim, I am going to talk about a few housekeeping matters just to get us set for today. So Q&A. We do welcome questions, and you can submit those questions through the Q&A tool located at the bottom of your Zoom window. If you do not see the icon, try to hover over the mouse in the general location until it appears. We will do our best to answer the questions in the time allotted. However, if we run out of time, and to the extent you've identified yourself, we will attempt to follow up with you individually. CLE. So today's program has been approved for distance learning CLE credit in Pennsylvania, New Jersey, and Delaware. And as a CLE provider, we must be able to verify your attendance. So at random points throughout this webinar, we will display and I will verbally announce 2 numeric reporting codes that you must record and report back to us using a CLE survey that you received in advance of today's webinar. We will in turn send your certificate of attendance once we receive your survey response. Please be sure to respond to the Saw Ewing CLE survey with your numeric code within 5 days of the program. All right, so webinar recording and handouts. We always get this question. Within 48 hours of the program, you will receive a thank you for participating email, and that will include links to the webinar recording and the program handouts, as well as the CLE survey. And finally, a legal disclaimer. The provision and receipt of information in this PowerPoint should not be considered legal advice, does not create a lawyer-client relationship, and should not be acted upon without seeking professional counsel who have been informed of the specific facts. And with all of that, I will now turn it over to Jim to begin.
Great. Good afternoon, and thanks very much, Christina. So I am Jim Taylor, and I thank you for that introduction. In front of you is the agenda that we're going to cover today, and as Christina said, I'm going to try not to recover the terrific presentations from Christina and Jim and Josh, and instead to focus on issues that they touched upon in the last 3 sessions, but specific to employees and the conundrum that's presented by the new regulations. I'm hoping to build on what they discussed. Of course, if I say something different or contrary, trust them, not me. But I do believe that in each of the issues that are reflected on this agenda, there are specific items, specific issues for each university to address. Finally, a special thanks to our colleague, Carolyn Pellegrini, who works with all of us on employment matters here at our firm and was instrumental in the preparation for today. So thank you very much, Carolyn. So let's get into the merits. Who's covered? There are some good news, and you might not have expected to hear that, particularly if you've been wrestling with and scratching your heads on campuses asking, so how is it that I am supposed to get all this done by August? And how is it that I'm supposed to align these contradictory policies, agreements, procedures with what the Department of Education has now decreed we must have in place by August? And so I thought it would be helpful to start with what I see as the good news. And Chris, if you would go to the next slide, please. Thank you. So there is some. You can largely decide who has actual notice on your campus. As we all know, and as you've heard, it's clearly the Title IX coordinator. That's always the case. But it's also now much narrower than it was with respect to responsible employee. And it's now any official who has authority to issue corrective measures on behalf of the recipient, on behalf of the university, college. So that's a significant change. There are pros and cons that come with that, and certainly some policy questions to be addressed on your campuses, but that gives you some control that you didn't have before. Similarly, you get to decide who is trained. And very importantly, there's no liability for training everyone. So unlike the past where everyone was a responsible employee and we had to be thoughtful about to what degree we were training them and including them within that category, there's now no liability for training everyone, which is great. You also can decide whether to align your non-Title IX processes with the prescribed process for Title IX. Again, a choice, pros and cons on various sides, and I'm not suggesting for a second an easy choice, not suggesting for a second that there aren't a lot of pitfalls associated with that, but it's nevertheless a choice. It is not prescribed for you what you must do. Only thing that's prescribed, of course, is that if it is an issue, an allegation of sexual harassment that falls within the definition of the regulations for Title IX, you must follow the prescribed process. Outside of that, you have choices. Also, and believe me, I'm going to get into this later, but you may not need to amend employment policies and agreements by August or at all if you focus on the difference between the Title IX remedy and discipline of an employee, including faculty members. And I'm going to talk about that in a little bit. You also get to decide the standard of evidence, well, at least maybe. You have a choice, but you must apply the same standard, preponderance, clear and convincing. You must provide the same standard for students and employees. We'll talk about the various factors that come into play there. And then, not that any of us start our day saying, gosh, I can't wait to put employees on administrative leave, but you still have the ability to place most respondent employees on administrative leave. Again, a powerful tool in our arsenal if we need to employ it in the right circumstances. So with that, Chris, let's go to the next slide, please. So you may be asking, and I won't belabor this point, but you may be asking, so Title IX and employment, I know about students, why employment? This is not new, and I won't read the definition or rather the statutory language with respect to Title IX and what it covers, but it speaks to all persons. And of course applies to any educational program or activity receiving federal financial assistance. That text doesn't mention specifically employees, but Title IX's reach to employees is not new. The Education Department kind of treats this as similarly to its powers and authority in connection with Title VI, I think it's a typo, Title VI regarding race discrimination in federally funded programs. And existing Title IX regulations already applied to employees in Subpart E. In fact, the US Supreme Court was asked to decide this issue in 1982, and in the North Haven versus Bell case, it said that the education department had the authority to promulgate the regulations and to regulate employment under Title IX. And then finally, it applies to all employees, regardless of function, so long, of course, as they're in the US. We're going to talk in a little bit about the interesting, to put it mildly, potential conflict, in quotes, between Title VII and Title IX. And I think that to set the table for that, the quote from the department's preamble is particularly interesting, where the department said, "We do not wish to apply the same definition of actionable sexual harassment under both Title IX and Title VII because such an application would equate workplaces with educational environments." Strikes me as interesting that while they say that on the one hand, they nevertheless require the same standard for both students and employees, and that's something we're going to have to wrestle with. Finally, throughout the preamble, there are a number of references to the two kind of guiding cases that the department is leaning upon here. One is the Davis case, you're all familiar with it probably in the student context. But there's a similar case, about a year, I think it precedes Davis by about a year, the Gebser decision, which said that where a school has actual knowledge of an employee sexually harassing a student, but responds with deliberate indifference to that, that the school is engaged in discrimination in violation of Title IX and created a private cause of action and the ability for damages there. So again, this is not new, but the department has really seized upon the Gebser and Davis decisions, Gebser employee, Davis for student, to put forth the new regulations. Next slide, please, Chris. I won't belabor these points. These are the existing regulations, except to say, so again, this is the subpart E of the existing Title IX regulations already in existence. But I want to emphasize this one point. Activity or program means all the operations of the university, all of them. And so, as I said earlier, this is very broad in its application and focus, and the need for universities to make sure that across the board, we are compliant with Title IX, whether we're talking about collective bargaining agreements with our faculty, with our other non-faculty unions on campus, with employees more generally, and as I'm going to hopefully touch upon at the end, even including employment at will. Next slide, please, Chris. So just a brief recap before we talk about the particulars. The final regs require that we respond promptly to claims of sexual harassment. You know that. What does that mean? Offering supportive measures, refraining from imposing sanctions on a respondent without first following the prescribed process, investigating every formal complaint, and effectively implementing remedies designed to restore or preserve. And focus on that language. I'm going to come back to that later. Restore or preserve a complainant's equal educational access. And a complainant or respondent here can, of course, be employees. It could also be that they're both. The new Title IX regulations clearly apply to employee on employee sexual harassment. You also, of course, will have student employees, students who are wearing both hats. They're your student. They're also employed by the university in various capacities. We're going to talk a little bit about how those student employees are affected today. Next slide, please, Chris. As I said, there's no more responsible employee concept. So the question is, who has authority to institute corrective measures on your campus? And as I said in the beginning, a little bit of good news. You have the ability to and the discretion to determine who that might be on your particular campus. Now, in some states, responsible employees are actually defined by state law and various obligations are imposed on them. Sometimes a reporting obligation, et cetera. Obviously, every situation is different, but in most of those cases, there's not going to be a direct conflict between what the state law might require of a defined responsible employee and the regulations, because the department says you can do more. We're telling you who at a bare minimum is going to be determined to have actual notice when they learn of an issue of sexual harassment. And that's a responsible employee and someone who has authority to institute corrective measures. You can define who that is on your campus, and you can go broader than that. In other words, you can include whoever you want in the authority to institute corrective measures. There were several comments to the proposed rulemaking that asked, well, what about the NCAA obligations to train coaches and trainers? What about Clary obligations to train CSAs? And the department says throughout the preamble, not a problem. Yes, there may be a lot for you to do, but that's not a conflict with the rules here. Next slide, please, Chris. All right, so we very quickly and admittedly quickly talked about, so who's covered? Generally speaking, all your employees. So now let's talk about how do we reconcile Title VII, which I think we all think of in the employment context, and Title IX? And do I have to comply with both? And the answer to that last question, do I have to comply with both, is clearly yes. Next slide, please, Chris. So as a starting point, the Department of Education says that it does not believe there's any inherent conflict between Title IX and Title VII. It believes you can do both. You can comply with both. It also says it's going to construe the application of the Title IX regulations in a way to avoid any conflict with Title VII. On the other hand, they of course say what we all know, which is, well, so now I have two different statutory regimes, statutory requirements, regulatory requirements, and I must comply with both, period. And so what that means practically, and we're going to talk about it in a minute, is you can decide, easily said, not easily done, but you can decide whether and to what extent you apply the Title IX prescribed regime that you've heard so much about over the last couple of weeks, live hearing, cross-examination, very prescribed process. You can decide whether to have two separate processes for your employees. One process for those claims of sexual harassment that fall under the Title IX rubric, one process for those that fall outside of that. Next slide, please, Chris. So just very basically, and I won't read all this, but very basically, the differences between Title IX and Title VII can come down to sort of two basic things. For the Title VII conduct to be actionable, it has to be severe or pervasive, and affect a term, condition, or privilege of employment. And there's vicarious liability under Title VII that attaches in those circumstances. The university can be held responsible for the acts of its employees. As I said, the department affirmatively chose, could not be any clearer on this, the department affirmatively chose not to align the two, Title VII and Title IX, for these purposes. Instead, the department has said, we've heard about this too, that quid pro quo and VAWA offenses are per se actionable. They per se affect the education, the access to the educational environment. The most significant change, though, and distinction, is that in order for conduct that's not quid pro quo and not a VAWA sexual offense to be actionable sexual harassment, it must be objectively offensive, deny equal access to a program or activity, and then the key words, is severe and pervasive. Big difference from Title VII, and we're going to see in a minute in a clear example of how that differs, but big difference. Severe or pervasive, Title VII, severe and pervasive, Title IX. Next slide, please, Chris. So the department also says that Title IX is not designed to be, quote, a civility code, and that these prescribed processes and regulations apply only for conduct that meets the definitions that we just talked about. There's, of course, overlap So number one, you can imagine, as this graphic hopefully attempts to portray, or hopefully portrays, you can decide what conduct you're going to govern on your campus under a general code of conduct. Of course, sometimes that's in faculty policies and handbooks, sometimes it's in different policies, sometimes it's set forth in contractual obligations like CBAs. But you can decide what your overall code of conduct is going to be in connection with employees. Within that, you will have conduct that is covered by Title VII. I would suspect that most of your institutions govern and handle complaints of Title VII through your ordinary code of conduct. Title IX now throws an additional layer. And Title IX says you must, under these regulations, use the prescribed process that we are all becoming familiar with. And there's, of course, a little area where conduct could fall both within Title VII and Title IX. And in that situation, we must apply the Title IX process. And so for the quid pro quo, faculty member says, do X for me and I'll give you a better grade, that clearly falls under Title IX. For the VAWA sexual offense, clearly falls under Title IX. For Title VII, so let's imagine conduct that's severe but not pervasive. So it's not a VAWA sexual offense, it's not a quid pro quo, but it's certainly something the university wants to attend to. Then it's either severe or pervasive. You'd cover that, it's certainly covered by Title VII. It is because it's severe or pervasive, it's not subject to Title IX. Therein lies a huge question for you, which we'll talk about in a second. Next slide, please, Chris. So in some respects, the Title IX definition is broader than Title VII. What do I mean by that? Well, if an employee supervisor fondles an employee's breast just once, and this is an example that comes right from the preamble and a case that's cited in a footnote. So fondles an employee's breast just once. Again, employee conduct here. And no harassment occurred before it or after. So it's not pervasive. So what the court has said in that underlying case, leave aside whether I agree with the thought that that's not severe or whatever we may think of that conduct, certainly an employer is not going to ignore that conduct. But what the preamble says and what the case that it relies on said is that that was not severe. And of course, it's not pervasive because it's a one-time incident. So you go through the text. Is it unwelcome? Yes. Is it based on sex? Yes. It occurred in the workplace, of course. It's not a quid pro quo. It's not severe, again, according to what the case said. It's not pervasive under these facts. But it is fondling for purposes of deciding that it's a VAWA crime. And so those individuals who are going to be administering this on your campus are going to have to be familiar with not just quid pro quo and the test, is it severe and pervasive and objectively offensive. They're also going to have to be familiar with the VAWA crimes. And I won't speak any more about VAWA and Clary today because Christina, who was moderating, is very much an expert in those areas. But she has pointed out some interesting questions and interesting dilemmas that are posed by the definitions that are relied upon in the preamble for purposes of the VAWA crimes and how some of those are evolving even as we speak. Next slide, please, Chris. So it's also a little bit, Title IX is also a little bit narrower than Title VII. And what do I mean by that? So an employee supervisor calls the employee a derogatory term based on sex multiple times per week for a year. And again, the regulations and the preamble and the citations cited in the preamble say that that's not severe. Again, leave aside our own particular thoughts about that, but let's assume that objectively, legally, it is not severe. Is it unwelcome? Yes. Is it based on sex? Yes. It occurred in the workplace, so it's covered. It's not a quid pro quo again. It's not a VAWA crime this time, unlike the fondling example a moment before. And so then you get down to this big distinction between severe and pervasive, or severe or pervasive. And in this case, because it's pervasive at a minimum, then it's covered by Title VII. Because it's not severe, again, according to the authority, then it would not be covered by Title IX. Next slide, please, Chris. So if I was you, I'd be sitting there saying, thanks, Jim, for telling me things that I could probably read on my own. So now what? So it presents two fundamental policy questions for each institution. Number one, do you want to align your Title IX process and your Title VII process? And two, do you want to align your student code of conduct and your employee handbook? Now, we know that we have to have the same standard of evidence for sexual harassment involving students and employees, but what about the other procedures? And we may be thinking about, of course, I've been talking about Title IX, of course, sex discrimination, Title VII, sex discrimination. But of course, Title VII is a lot broader than sex harassment, including race discrimination. And so issues to think about, and no, I'm sorry to say I don't have any crisp answers for you today, but issues to think about are, do you want to deal with the race issue? Let's assume you have conduct that alleges both sex harassment covered by Title IX and race discrimination. Do you want to cover by Title VII? Do you want to cover both in your Title IX proceeding? If not, what are you going to do? Two different hearings, two different decision makers? How will you align that? I think if I was crafting the policy and I had the carte blanche to do it the way I'd like, I would have, if any issue is covered by Title IX, then the whole complaint is governed by that process. Otherwise, you end up with the potential for different decision makers, or at least different decisions under those different processes. But you may not be able to accomplish that, or there may be other good reasons to not do it that way. And so if you're going to bifurcate the decision, the process, Title IX, Title VII, how? Could you do it in one hearing? That sounds really unworkable to me. Could you have two different hearings with identical facts? Maybe. What if you get two different outcomes? How would you document that? And if you fast forward all the way to the end, which is, so imagine that I'm sued, of course, because someone's unhappy in this situation. How am I going to demonstrate both that I wasn't deliberately indifferent under the Title IX process and that I complied with the Title VII process? And what are the effects of liability if a hostile environment was to persist under Title VII because I adjudicated claims under Title IX, but the Title IX rules made it difficult for certain evidence to become admissible, as you have no doubt heard, and as Josh so sort of eloquently and clearly described it, I think last week. If the witness is not available for cross-examination, then it may not be used for the Title IX process. Hearsay is not going to be a permissible basis on which to find the Title IX violation. Your process may allow hearsay for Title VII, consistent with due process, or for privates, whatever rights we may provide to the employees there. But something to think about: different evidentiary issues, different admissibility issues. You spend a lot of time, obviously, wrestling each one of those to the ground. All I can equip you with today is these are decisions that you, good news, have the ability to make. Bad news, you have the ability to make them. And so there's not a right or wrong. There's not a clear, you must do X. The only clear guidance is that if it falls within Title IX and Title VII, we have to follow our Title IX process for the sex harassment piece of it. And of course, we must use the same standard of evidence that we're going to talk about in a little bit. Chris, next slide, please. Now, the universities that I've spoken with in connection with this in the employment setting have naturally just said, how can I possibly get this done by August? And so it's important to think about both, of course, the practicality that the entire world is living under and all of you are living under, but also what we have to have done. All we have to have done by August 14 is a policy and procedure that we can train on and follow and that complies with the regulations. Yes, that's a lot. I'm not suggesting for a second that that's simple, but that's all we have to have in place by August 14, the effective date of the regulations. These other issues, these questions about how do I align my processes, how do I make sure that the Title VII race discrimination complainant, who's also got a sexual harassment complaint under Title IX, doesn't feel like he or she is being shortchanged because the race discrimination claim is being dealt with through a different process that may feel more or less fair to the respondent or complainant, depending on how it's drawn up. And so those are practical questions that you don't have to have answered by August 14. But of course, if you're looking at me and you're saying, well, yeah, sure, Bright Eyes, I don't have to have them answered, but I better know where I'm going when I design my process, when I think about my training, and when I talk to my employees, both my at will, my student employees, my unionized employees. And the answer to that is yes, of course. You need to be thinking about where you're going to go. The silver lining I'm trying to give you is that you don't have to have all the answers firmly in place and all of your policies and procedures and contracts, to the extent you can, redone and revamped in time for August 14. Next slide, please, Chris. Let me just spend a minute talking about supportive measures and administrative leave. Next slide, please, Chris. Thank you. So supportive measures, again, covered in the last couple of sessions, now must be provided to a complainant. That, of course, applies to employees too. And they're fact specific, right? I actually think that there was an interesting and I thought illustrative example used in the preamble of saying, think of this as akin to the interactive process that we're all familiar with under the ADA. Fact specific, think about it as the interactive process. At least for me, that helped crystallize a little bit about what's going on and how it is that a university might engage in this kind of conversation, the parties to a Title IX dispute. So it can't be disciplinary, can't be punitive, can't be unreasonably burdensome. There are other requirements set forth in the new regs. But that doesn't mean that it can't have a burden. It can't be unreasonably burdensome. We're going to talk about that a little bit when we get to students. The guidance in the preamble also says that a no contact for employees is still possible. A no contact order, employee X, the complainant, stay away from employee Y, the respondent. Still possible. Next slide, please, Chris. So when can we put non-student employees, so your traditional typical employee, not wearing two hats, when can I put non-student employees on administrative leave? You can do that during the pendency of the grievance process. And you can't impose disciplinary sanctions under the grievance process until it's complete. Those come right from the preamble, and actually those come right from the regulations. And in the preamble, interestingly, the department concedes, as I think it has to, that placing an employee on administrative leave without pay is generally considered to be disciplinary, right? That's no surprise. And so if I'm told that I can't impose discipline until the grievance process is completed, but I'm allowed to impose administrative leave, why is that? And the simple answer is that the department wanted to make sure, and it says this much, the department wanted to make sure that a university had the ability to remove from campus an employee who was sexually harassing a student, not limited to that, but certainly to be able to deal with that situation, even if the adjudication was not complete, even if the grievance process was still ongoing. And so that is just an explicit permission that exists in the regulations. For student employees, sorry, next slide, Chris. Actually, let me cover student employees now, but you can stay on that slide, Chris. For student employees, it's essentially what the department says is treat them as students in this situation, not as employees. So what does that mean? Ask yourself whether you can put a student on leave who's wearing the employee hat under the supportive measures test. And what the department there says is you may be able to place a non-student employee on leave, and that the regulations, and this is a quote, do not necessarily prohibit a recipient from placing a student employee on leave. It may be permissible as a supportive measure for a complainant, but it can't be punitive, disciplinary, or unreasonably burdensome. Why? Because the department is concerned that placing a student employee on leave from the employment position may itself jeopardize the student employee's access to educational benefits and opportunities. Again, creating a problem under Title IX. And so, yes, we have the ability in very limited circumstances, I would say, to place a student employee on leave, only if we can do so consistent with the prescription for supportive measures, and only if doing so is not unreasonably burdensome and wouldn't jeopardize the student employee's access to educational benefits. Again, going back to very fact-specific, think interactive process when you're thinking about that question. Okay, so we also still have the ability, and this was covered in the student processes that were covered over the last couple of weeks. We also still have the ability to remove any respondent, including an employee, from any portion of our property, including an employment position, in an emergency situation. So in that situation where there's an emergency, threat to self, threat to others through that process, then there doesn't have to be a grievance process pending. We have to fit the definition of emergency, but we still have the power. A university still has the power and the right to remove somebody from our campus in that situation. For the non-student employee respondent on administrative leave, we have the ability to do it, but it has to be during a grievance process. And that is why, or that is how the department believes that this will be quote unquote policed. Why? Because you have to have in your grievance procedures a general requirement that you will handle your complaints of sex harassment in a prompt fashion. And so the department believes that that strikes the right balance. You can put a non-student employee on administrative leave during the grievance process because a grievance process, once started, must be completed in a reasonably prompt time period. The department also, interestingly, doesn't attempt to dictate whether that's with or without pay. What the department says over and over and over again in this context is that what it wants to do is leave the recipient, the university, with flexibility in this space. I'm going to go back to, because even though, of course, the focus on this is Title IX, there are a lot of other provisions, state law provisions, contractual provisions, policies that could come into play about whether or not leave is with pay, without pay, whether expenses are owed, and under what circumstances, whether somebody who's quote unquote wrongfully placed on leave is entitled to back pay. And all I can do there is, of course, number one, start with very fact specific, but number two, take you back to what the department says repeatedly throughout the preamble, which is we are not going to construe Title IX to be in conflict with these other requirements that provide additional layers of protection or rights. Think of Title IX in this situation as providing a floor, but we can do more. And then it may be self-explanatory, but the other thing the department says in connection with leave is that it cannot be indefinite. Why? Because it requires that a grievance process be in place and done within a designated reasonably prompt time frame. I already covered this last point, which is a student employee. Yes, you can do it, but emphasis on very carefully. Why? Because we have to make sure that we are cognizant of and being respectful of the respondent's own educational rights. And we have to do it under the supportive measures rubric. Final point, and then I think we're going to take a pause for questions. Informal resolution. You may have heard about this. Can we have an informal resolution? Yes. You may have it for employee on employee sexual harassment. You may not have it, period, full stop. You may not have it for allegations that an employee sexually harassed a student. And why? Well, the department says it's too difficult to determine in those situations if it would truly be voluntary. In a similar vein, the department said that an employer, the university employer, cannot force an employee to waive the right to file a formal complaint or proceed through a formal complaint process as a condition of employment. So we can't have it, period, for allegations that an employee sexually harassed a student, too difficult to determine if voluntary. We also can't require employees to give up this right. That may not be a surprise, but it's a similar notion of it wouldn't really be voluntary in that context. Next slide. Thank you.
All right, Jim, I think you covered informal resolution, so if we could just go one more forward. Before we take some questions, this is the first CLE code for those of you that are looking to get CLE credit. The CLE reporting code is 402109. Again, that's 402109. All right, Jim, so we had a couple of questions come in, and I'm just going to go through a few of them. We may need to save a few for the next segment for questions that we do have later in the presentation. So let's talk about something you were just referring to, which is the concept of paid or unpaid leave. The question is, and for clarification for the audience, is for non-student employees, can the institution put them on paid leave during the grievance process?
Yes.
Okay. All right.
I like questions that have simple answers. Not that it's a simple question, but I like questions that have simple answers. Yes.
Agreed. I just want to make sure that was clear. Okay, so then in terms of student employees, right, just the general concept, is there anything in the regulations or in discussion to confirm whether or not that would include medical residents if the medical system is somehow affiliated with the university? And would the answer be different if it was separate from the university?
So I can give a partial answer on this. There is a lot in the preamble that talks about the distinction between medical centers, universities that have a medical school, and affiliations with hospital systems. There is a lot in the preamble. And I would be hesitant to go kind of farther than that without having a particular focus on what is the precise question and the relationship and how is that dealt with in the preamble. But the department preamble recognizes that there are distinctions, key and material distinctions between medical centers and traditional university. Christine, anything you would add to that?
No, I think that's right on. Okay, so then this one came in and says, if this example, I think the question came in when you were talking about the example of the one employee placing their hand on the student's breast one time. Mm-hmm. And the question is, if this example happened between an employee and a student, would it automatically be considered quid pro quo? Or does there have to be something definitive indicating that the employee was asking for something?
So we have an employee, and that's in that hypothetical. The employee is the one who is groping the student's breast. So my answer, I don't think it's quid pro quo unless there are other facts to color around that. It is fondling under those facts for a VAWA violation. So it's still one of the, what I call, or what I think others have referred to as a per se violation. I don't need to go more. I don't need to know more, but I don't think it's quid pro quo.
Yeah. And I would agree with that. And I want to highlight, because we had a separate question that was asked about that. So the concept of fondling, I agree with Jim. If there wasn't an ask for something, it would qualify as fondling if it was for the purposes of sexual gratification. And as Jim is saying, the per se, what that means is for quid pro quo and for the third category of sexual harassment, all of the VAWA, clearly related incidents, those do not have the same requirement to be objectively offensive, severe, and pervasive, and effectively denying the student or the person. So I would agree on that. All right, why don't we take one more and then we'll jump back into the slides and we can always do some additional questions. All right. All right. I think you had talked a little bit about the concept of not submitting for cross-examination. So the general question here is, and I'm happy to chime in as well, do the Title IX regulations eliminate all hearsay or permit the accepted hearsay exceptions?
My quick answer is neither. The general rule, and the thing that I was alluding to, is that if we are basing the decision on traditional hearsay, student X observed conduct, and that person would be a witness, but the witness tells the investigator, yes, I saw it, and here's what it is. It is not available for cross-examination, does not make him or herself available for cross-examination. We cannot use that in the adjudication, period.
That's correct. And there are a number of pages in the preamble that even get to the concept of that prohibition relating to cross-examination and just the department's hesitation to adopt hearsay and other evidentiary rules. So to the extent that the questioner has questions, we can point them to that page if needed. So with that,
and the reason, sorry, let me just embellish for just a second on why I said neither instead of answering it that way. So the traditional exceptions that we might think of under the applicable rules of evidence in a court system, that's not the rubric that we apply. You would not be able to use statement from a third party if that person is not available for cross-examination. There is, and you may have seen some chatter about this on NACUA.net, for those of you who are members, there is some question about, and I think it's now been largely resolved, but some question about, well, what if the conduct itself was an out of hearing statement? You know, the respondent actually said something that itself constitutes sexual harassment. You can't be really telling me that I can't look into that and that I can't use that as a basis for the adjudication. I think that's now, even though traditional hearsay, you're not applying the traditional rules of evidence for hearsay exceptions, but you nevertheless can consider that through the process.
Correct. Okay, so then we have additional time for questions at the end. So I'm going to turn it back over to Jim for the slides.
Thanks, Christina. All right. Determining the standard of evidence. As I said, the same standard, preponderance or clear and convincing, must be used for both students and employees. If there's one very clear, bright line rule that you can take from the regulations in the preamble in the employment context, it's that, plainly stated. Next slide, please, Chris. And the standard for finding a violation of a Title IX policy and the imposition of a remedy, and I'm emphasizing these words, imposition of a remedy, for a reason, because I'm going to go back to disciplinary measures later. But the standard for finding a violation of Title IX and imposition of a remedy has to be the same for students and employees. And so if we lived in the world where there were no other strictures, no state law requirements, no contractual requirements and obligations, you would have complete choice to decide, well, do I want preponderance or clear and convincing, and do I want that, and which one do I want, and then I use it for all circumstances. And again, I want to make this point particularly clear because, frankly, it took me a little bit of time to realize that I needed to stop thinking about just faculty, which is where my mind always went to when talking to universities about this. It's all employees, period. And so, yes, there are a lot of obligations that we have to our faculty, various sources of that. sometimes even state law we're going to talk about. But this applies to all employees, period, on our campus. The next slide, please, Chris. So as demonstrated by either the fan or propeller, depending on what your proclivities are, there are obligations that, of course, come from Title IX, state law, CBA, and handbooks. Because of this, because it's not just Title IX that speaks to this, some who commented on the proposed rulemaking said, this really isn't a choice. You may say it's a choice, department, but it's not a choice for many of us, because some other source is telling us what we must apply either for students or employees. And I will say this is one place where, leave politics and policy prerogatives aside, the department is really unforgiving on this point in the preamble. It says several times, look, ultimately, you, the recipient, you, the university, choose to accept federal financial assistance. So this is your choice. You get to pick the standard. We're not telling you which one. If a CBA requires clear and convincing, or your state law has a particular requirement in this area, and you are wanting to follow a different one for students, or whatever the case may be, you have essentially two choices: renegotiate or don't accept federal financial assistance. That's not really a choice. And we're going to talk about at least a suggestion that we have for how we deal with that particular situation. But let's start with sort of state law issues. Next slide, please, Chris. And one more, please. So what if a state law requires the preponderance standard for determining whether a violation of the recipient's Title IX policy occurred? So state law applies. And let's assume that it applies in the student context. So the scenarios, and they're not, not particularly shocking, are they? The scenarios are, okay, so we apply the preponderance for all purposes, then we're in compliance. That's great. I'm not sure that that's as easily said as done in a number of our situations, but okay, that's a scenario. If we apply the preponderance in the student case, but not in the employee case, then of course, yeah, great, we've complied with state law, but not Title IX, so that's no help. And then if we apply clear and convincing in all situations, of course, we now applied with Title IX because it's consistent, but not with state law. And so the regulations talk a fair amount about preemption of state law. And the regulations talk about the fact that they believe, the department believes, and this obviously remains to be litigated, but the department believes that the regulations preempt directly conflicting state law. But the department doesn't think, and I agree with this, that there's not inherently a conflict just because state law says you must do X for students. You must have the preponderance standard for students. And yet we have, for example, a collective bargaining agreement that provides for clear and convincing. There's not a direct conflict there. You can harmonize, as the court would look at it later, you can harmonize those two. Different question from whether it's easy to harmonize them, but you can. And we're going to talk about that in a little bit about that. So next slide, please, Chris. So the department is going to construe the regulations over and over, it says, is to avoid a conflict. But if an actual conflict exists, then the department believes that the regulations preempt. And so there are several examples, or a couple of examples actually given in the preamble, and on the slide here, I give you the page cite for that. So, what if, for example, state law requires that for a unionized employee, that a union representative be present throughout the investigation and the process? And the department says, no problem, no conflict, because the employee gets to have an advisor of his or her own choice. And so again, not looking to find conflicts, not looking to find problems. Your state law there tells the employee essentially who that employee's advisor is going to be, no problem. And so then there's a citation to, and just to pick one, for example, New York's enough is enough law. And so the question is, if New York law requires a recipient to respond to conduct that the regs don't deem covered by Title IX. So what does that mean? Well, in New York, as I understand it, I'm not going to pretend to be a New York lawyer, but as I understand it, enough is enough law actually goes even farther than Title VII, and essentially says that if there is any conduct that fits under a very broad definition, including in creation of an inferior working condition, then that has to be addressed. That's what the state law applies or provides in that situation. So it's not covered by Title IX, doesn't fit the definition. And the department there says, no conflict. Even if a complaint is filed, as you've heard throughout the last couple of weeks, the complaint can be dismissed. Indeed should be dismissed, must be dismissed. And then you can proceed under your separate process, your non-Title IX process. Policy question, does that non-Title IX process look the same as Title IX? Does it look different? Policy question to be addressed on your campus. But the department says, not a problem. Okay, so then let's imagine this. What if the conduct as alleged fits the Title IX definition? So we don't have the dismissal situation that I just described. And the investigation finds evidence supporting the complainant, goes to a hearing, but the hearing determines that the respondent is not responsible under the stricter Title IX definition, but would have qualified, in other words, would have been found responsible under the lesser state law standard. Well, the one thing that's the additional thing that's very clear is that I can't have two different Title IX processes. So I can't say, well, you were found non-responsible for this conduct of sex harassment under Title IX. So now I'm going to have a different process and try to get a different result or see if there's a different result for purposes of the kind of lesser offense, if you will. Can't do that. And in that situation, there is a conflict. The department doesn't recognize that or purport to address it other than to say, in the situation of a conflict, and I think that example creates a direct conflict. In the case of a conflict, it preempts state law. I think we'll have to wait to see how that plays out in the courts over the years to come. Next slide, please, Chris. So CBA handbook, we'll actually go another slide. So what if the CBA or faculty handbook, whatever the case may be, but it's easy as shorthand to think about it in terms of CBA. What if the CBA requires a clear and convincing evidence standard for determining whether a violation Title IX occurred? And again, and I won't belabor this, but 3 scenarios, only one of them is fully compliant with Title IX and the CBA. And if you want to have a change to the standard of evidence that's different from clear and convincing as set forth in the CBA, sure, you can renegotiate with your union. I've yet to meet, and I think Josh put this really clearly last week, I've yet to meet a client yet who thinks that would be an easy process or perhaps even achievable. And even though I go back to what I said a bit ago, which is what we have to have in place by August is a Title IX compliant grievance process. We don't have to have in place all of these other things by August. That only gets you so far, right? Because if I have a collective bargaining agreement that says clear and convincing, and in my Title IX grievance process, I'm stating a different standard, then I've created my own conflict. And so what do I do about that? I promise that at least some thoughts about that are coming. And when we talk about collective bargaining agreements, I mean, as with any contract, the particular language will really matter. And so be looking for and thinking about not just something that is a very clear standard. X must be proven by clear and convincing evidence. But many collective bargaining agreements, if they don't have that sort of language, will have something a little bit more nebulous, like just cause, a little bit of a burden shifting sometimes. Sometimes they will also have provisions that say, before any action can be taken, a panel must find X or Y by Z standard. That isn't clear and convincing, but nevertheless would be different than what you'd want in your Title IX process. So just word to the wise, don't just be looking for precise standard of clear and convincing or preponderance. It may be written a little differently there. The next slide, please, Chris. So then, to make it even more complicated, what if a CBA requires the clear and convincing standard, but you happen to be in a state that requires the preponderance of the evidence standard for students? And again, we've got our three scenarios here. Here, there's no scenario short of a renegotiation that covers you with all three. And so that we've asked the question. So let's say then in that scenario where I can't, without a renegotiation, which I assume is not likely in most circumstances, at least not a quick renegotiation. What if there's a conflict between the collective bargaining agreement and the state law? Is the provision void because it's in the collective bargaining agreement? Is it void because it's counter to federal law? And I suppose different folks can have different opinions on that. I'm not convinced that there is a true conflict and prohibition and an automatic collision with federal law. Again, going back to, and some have actually ascribed some motives to the department and said this is a particularly cynical view by the department and a step by the department to create this quote unquote choice that really isn't a choice at all, may even be read as anti-union. Again, leave politics aside, that is what some commenters have said. In fact, a quote from the preamble at page 30274, the department acknowledges commenters' concerns that each type of employee at their university has its own grievance procedures, penalties, and appeals processes, as well as concerns about whether tenure may be implicated, but disagrees this presents a problem. The department believes that simply providing a range of sanctions to respondents is feasible despite this reality, and that otherwise you can figure out how to comply by figuring it out. And again, going back to its particularly stark response of, if you don't like it, don't accept the money. Next slide, please, Chris. So how do we possibly get our documents to align with the decision you want to make? So what if the CBA says clear and convincing and you choose to have preponderance, or would like to choose to have preponderance across the board? May not be able to renegotiate, but look carefully at your CBA or your handbook or whatever contract we're talking about. Courts are going to look to avoid a conflict. The department's going to look to avoid a conflict. But you may be able to find a savings or severability clause. I mean, the department actually cites in the preamble an example from a particular university collective bargaining agreement that says, if anything herein conflicts with federal law, then essentially deem this collective bargaining agreement to be so amended. I don't expect you're going to find that in your collective bargaining agreements. And again, I'm not sure that we actually have a conflict, right? We have a problem. I'm not sure there's actually a conflict. And so, but look at that. And Chris, if you go to the next slide, please. And these are on here. The slides will be available, so I won't read them. But you may also have a reopener clause. What is that? There's something that along the lines of what's here, which is if any provision of this agreement conflicts with applicable law, then we can reopen to renegotiate just that provision only. So it's kind of in the weeds on a labor matter, but that possibility exists depending on what your particular collective bargaining agreements may say. Next slide, please, Chris. So all right, we've got the potential for conflicts galore. Well, what can we do? So the department does recognize shared governance, of course, as it must in connection with universities. And so it affirmatively states that there's nothing in the regulations that preclude a faculty committee from hearing claims of harassment against faculty. Again, as long as we've complied with the hearing provisions and the regulations. So you can still have that. And a hearing officer can be a faculty member. Again, so long as trained and not conflicted and not biased and otherwise complies with the procedures and strictures set forth in the new regulations. And so we can still have modified process differences between employees and students. The baseline is clear. We know what we have to have under the regulations, but we can have different people involved and treat it differently when we're talking about employees versus students. Next slide, please, Chris. All right. I've said throughout the day that we would get to discipline. And this is, and I will give great credit to Josh Richards, who has been doing some leading thinking on this point, and you heard him allude to this last week. If you go to the next slide, please, Chris. So the final regulations do not require particular disciplinary sanctions. Right? We may all know this, but it's really important to hammer this home. Title IX is not there to sanction the respondent. Title IX is there to provide remedies to access to education and programs to the complainant. And so, great, Jim, why are you telling me that? Next slide, please, Chris. So, the question for consideration is, can the standard of evidence for imposition of discipline be different than for finding a violation? And the answer to that is, well, not really, but what does that mean in practice? So what I know I can't do is have two competing processes, both seeking to find looking to find a violation of Title IX. That's what I can't do. And I have to have a grievance process under Title IX for purpose of addressing formal complaints of sexual harassment, to provide remedies to the complainant where there's been a determination of responsibility. And we know that disciplinary sanctions may not be imposed until after the conclusion of the process. Next slide, please, Chris. But what are the remedies? What do I mean by remedies? Or forget what I mean. What does the department mean? What does it mean when it talks about remedies? They must be designed to restore or preserve equal access to the program or activity. And they may include supportive measures, and they may burden the respondent, and they may be disciplinary, and they may be punitive. I don't know why the department chose to write need not be non-disciplinary. I keep in my mind having to say maybe. But so what does that mean? I think that, and again, great credit to Josh Richards, who alluded to this last week, but we think as a group, that you can think of discipline, employee discipline, separately from the remedy to be imposed under Title IX. So if you imagine a situation where a professor teaches Intro to American Literature, and there's a claim of sex harassment brought by the student against the professor, well, the remedy could be that the student gets assigned to a different class. I'm not saying that's necessarily the best remedy, right remedy, but as a possible remedy. And so that discipline there to the faculty member is not necessarily the remedy. That's not to say, of course, that you wouldn't want to and choose to discipline the faculty member. And so there is a situation in there where you could imagine the Title IX process decreeing that the remedy is student gets to take the class with a different professor, and that there is a recommendation from the Title IX adjudicator to the appropriate faculty or other employee process that the process pursue removal or discipline, whatever discipline may be appropriate, of the employee. And so let's talk about what that could mean in practice. So I have a situation where my collective bargaining agreement says I can't, I'll just use the shorthand, punish an employee, faculty member, absent very clear and convincing X and Y and Z. I can't do it. If I go through the Title IX process and there's a finding of responsibility under, let's say, a preponderance standard, that preponderance standard is being used there to decide whether there's a Title IX violation against an employee respondent. So in that case, it's arguably, and we think it is, consistent, because the same standard is being used for students and employees, preponderance in that case. Then we get to, so what's the remedy? Well, in that situation, as long as the remedy that can be imposed and is being imposed to aid the student is something that the university can do through its Title IX process that doesn't run into conflict with the collective bargaining agreement, then again, we don't have a problem. And if that process ends with a referral to the appropriate committee or dean or whatever the process may be for the employee we're talking about, if it ends with a referral to say, this is what happened, these are the findings, and you, other process, should go forward and seek to impose discipline on the employee, then I think you can still do that. And I think you can do that even though you have two different written standards, clear and convincing in your collective bargaining agreement, preponderance in your Title IX process. Not suggesting it's easy, not suggesting it works all the time, but it is at least a solution to the, well, what do I do if I just can't get my collective bargaining agreement aligned because I can't reopen it, it's not necessarily in conflict, the union won't negotiate with me. And to be clear, there's no path there without risk, right? We could ignore discipline, but I don't think that most universities, any of you are likely to fall there. We could say we're not going to follow the collective bargaining agreement or handbook process. We're just going to use preponderance because that's what we're using in our Title IX process. And sorry, faculty member, but we're now going to discipline you here. I mean, that's not going to work when you get to the grievance stage. I suppose there, at least you've taken the action, and then the return to campus of the employee would be over our objection. But again, that feels pretty unsatisfying. And so then in this third situation is what I just described. We could follow the separate CBA process for discipline. And if we did so, again, not without risk, but we've done our best to comply with two different prescribed processes and standards. We've done what I think the regulations require, which is use the same standard for a finding of responsibility and imposition of remedies. And we've taken away at least the argument that we're not following our collective bargaining agreement from the disciplined employee there. Next slide, please, Chris. And I think this just restates what I just said, probably more clearly than I just said it, which is the imposition of a remedy must occur within the grievance process. The imposition of a disciplinary measure or sanction need not. And so again, just restating and emphasizing what we had just talked about. Chris, would you go to the next slide for me? Thank you. And one more. Sorry, I put too many different headings in for you, Chris. All right, let's talk about training. Which employees do we have to train on the Title IX policy? As I said at the very beginning, and as you all may now be familiar with, the concept of responsible employee is no more. You may have state law that still speaks to it in a non-conflicting manner, but at least under the Title IX regulations and regime, concept of responsible employee is no more. Instead, it's the Title IX coordinator and any official who has authority to institute corrective measures on behalf of the university. Very different rules for elementary or secondary school, so just keep that in mind. I know that's not likely any of you, but nevertheless something to remember. Next slide, please, Chris. So if I had to put it into a phrase that I don't think is mine, it would be you can train without fear. That's good. That's great. That is a help. That we don't have to worry that just because we've trained X employee or X group of employees that all of a sudden they are individuals who are now subject to triggering the actual knowledge requirement. You must train the Title IX coordinator. You must train those who have authority to institute corrective measures. And there are separate training requirements for individuals involved in the investigative, the adjudicatory, and the informal resolution processes. So those are the categories you must train. You may train all employees, as I just said, train without fear. Who should you train? How broadly should you train? It's unlikely that your current Title IX training complies with, in other words, covers and isn't in some ways, or maybe materially, inconsistent with the new regulations. So you're gonna have to change it. So do you want to retrain those who were trained under the old regime? Do you want to retrain everybody? Do you want to pick certain segments of your employee population who you're going to retrain? It's not a right or wrong on that. I mean, I think what you should be focused on, and what I would be focused on in making those decisions is, who is most likely, there's no secret here, no surprise, who's most likely to come into contact with a Title IX complaint. And at a minimum, I would think about training them, even if that's broader than Title IX coordinator and an official who has authority to institute corrective measures. And, the department in moving from responsible employee to this concept is clear that it wants to do a couple of things. Again, leave policy and right or wrong aside. What the department wants to achieve is flexibility for employers, universities, incentives to train employees. Why? Because there's no increased liability from an actual notice perspective if you broaden your universe of trained employees. Discretion. Who do I train? What does it include? And it also wants to, what it refers to as, respect the autonomy of post-secondary students. And what does that mean? Well, it says in so many words that post-secondary students, university students may need to go and confide in trusted adults on campus. And the department wants to get away from the notion that when that happens, there's an automatic report, and instead get to the context of giving the complainant as much power as possible. And so while most of the regulations speak about that concept in terms of student complainants, it's nevertheless a concept that rears its head a lot. Give the complainant as much control over the process as possible. Next slide, please, Chris. And one more again. So how do the new regulations affect the at-will employment doctrine? The answer is that they do to a degree. I'll end with the headline, which is, it may not be a surprise to any of you, many of you who touch employment concepts, know that even if there's an at-will employee, you can, of course, terminate for a bad reason. And it's always helpful to have a legitimate, non-discriminatory reason for terminating. But where there could be a rub, and where we just have to be cautious, is that what we can't do is have our legitimate, non-discriminatory reason be a Title IX sex harassment claim if we didn't adjudicate that claim through the prescribed process. And that's how it could affect the employment at will concept. If we have an employee at will, there's an allegation we cannot, that fits within the Title IX rubric, and the formal complaint is filed, or even if it's not, we can't use the basis of that allegation before a process and an adjudication and a finding of responsible. We can't use the mere allegation as that's it, we are going to part ways with employee X. That may not feel like it's a big issue, or maybe it does. Where I particularly see the risk here is with respect to adjunct faculty, many of whom work on sort of relatively short appointment letters, maybe for a semester, maybe for a school year. And I've run into this situation before where there's an allegation, not necessarily sex harassment, doesn't matter. There's an allegation, a whiff of something that maybe is inappropriate or untoward, And a university has to confront the choice. Well, do I gin up an entire investigation here, or do I just decide I'm not going to quote unquote renew this contract or this agreement? In that situation where the person is clearly our employee and would be deprived of employment as a result of allegations of sex harassment, without the full panoply of protection under the final regulations, then I think we have a problem. And that's something to keep an eye out for. Next slide, please, Chris. Does the Title IX policy, so I started with, does it apply to employees? Clearly the answer to that is yes. The next question is, does it apply to non-employees? And the short answer to that is maybe. So the regulations say we're going to look to the department are going to look to state law to determine who's an employee, who's an independent contractor. Okay, fine. But if the non-employee is a complainant, then I believe that the Title IX regulations apply. And if the university gave the non-employee the authority to institute corrective measures, then there too, Title IX could be implicated for purposes of actual notice. That may not be something that's front of mind for you, but certainly possible in some settings. And as I say, who is an employee is determined by state law. You also have to keep your eye out for volunteers. There is what I think is a rather oblique reference to volunteers on one page of the preamble, which I've cited here, with sort of what almost seems like a throwaway line. Oh, by the way, all this could apply to volunteers. And so you ask yourself when you run your process, if there's a volunteer who is covered by the university in some respect, who makes a sex harassment allegation, an obligation to pursue under the process. Whether or not you can actually have a volunteer as a respondent, I think will come down to what remedies can be imposed. If a university receives a complaint by someone who alleges sex harassment by a university volunteer, the university can't ignore that, has to go through its Title IX rubric, has to follow the grievance process, in my view. If the volunteer is a respondent in that situation, then there may be limited remedies available to us. On the other hand, the remedy may be as simple as, well, then that person is no longer a volunteer, or we're otherwise going to make sure that the volunteer and the complainant are not are kept separate. And again, going back to the point that I belabored, there is a difference between remedy to fix the Title IX violation and discipline of an employee or someone else. Next slide, please, Chris. All right.
All right, and with that, we have brought ourselves to the next segment for questions. Before that, of course, is the second CLE code. So for those of you looking to get CLE, here is the second code you will need. 998256. Again, that's 998256. All right, so Jim, we do have a few more questions to bring us home. The first one is about advisors during a live hearing process. Do you have any suggestion, or does the preamble discuss who should be utilized as an advisor for a live hearing in a matter involving an employee respondent and a student complaining, assuming the students or the parties don't have their own?
Mm-hmm. So I'll answer the kind of preamble question first. Does the preamble have a discussion on that? Yes. The preamble talks about the fact that there was concern in the comments to the proposed rulemaking that, well, gosh, couldn't you have a situation where a well-heeled faculty member, I can't remember if the name Johnny Cochran comes from the preamble or if I read that or heard it somewhere else, but either way, think Johnny Cochran being hired by the well-heeled faculty member, and the student who is down on his or her luck just doesn't have the means, and doesn't that create a huge disparity in the process? The department's answer to that, I don't think this is a complete or particularly helpful answer, but the department's answer to that is, well, gosh, it could just as easily be the opposite, right? A particularly well-heeled family who can bring to bear all sorts of legal and other resources and have a kind of the quote Johnny Cochran representing the student in the advisory capacity, and a faculty member might not have those choices. My suggestion there, and there has been a lot of chatter, and there will continue to be a lot of chatter about sort of the panels of advisors that universities may point students and employees to. And at least one suggestion that I have, and Christina may have different ones and may even disagree with this, but I think there's some real value in having a panel of advisors and saying to the students and employees who may ask for a university appointed advisor, here's the panel, you go talk to, you go kind of contact them and see who might be available. And so that we are not in the business of picking and choosing who gets what, but we have said sort of here is our group of our panel of potential advisors. That's going to work in most situations. I'm not suggesting it's easy. And of course there's a cost that may come with that, but on the risk spectrum, ignoring it is not going to solve our problem. And that's at least a way to address it.
Yep. And I've heard similar things about having a panel so that the individuals essentially have choices. So I have heard that as well. Okay, so then going back to the emergency removal process, okay? Mm-hmm. The question is, do I understand that you only have to use the emergency removal process with a non-student employee when there's not a grievance process pending, but you always have to use the emergency removal process with students regardless of whether a grievance process is pending?
All right, so let me do it the other way and see if I answer the question.
Yeah.
So you may use the emergency removal process for any respondent, student employee wearing two hats. You may, if the test for emergency removal is satisfied, which is a very fact-specific, particularized test requiring a threat, direct threat. And so it's limited, but that is always available. And because it's always available, there is no requirement that there be a grievance process commenced in connection with that. For the non-emergency, so I'm going to call it administrative leave in contrast to emergency leave. For non-emergency administrative leave, you can only use that during a grievance process. Mm-hmm. And that's, again, this balance the department thinks that it is struck between, well, we want to give the university employer the ability to remove a faculty member or any other employee who may be harassing a student while the grievance process continues, and yet not to make it indefinite and not to, create a real risk of due process issues, so that the grievance process, which has to be handled in a prompt fashion, is there and addressed. So hopefully that answers the question, but that is the situation. I guess I could take it one step further. So then for student employees, right? So the student employees, this is where you can do so. You can place the administrative leave. Again, emergency leave always available. Administrative leave maybe with student employees, but don't think of it in terms of administrative leave. Think of it in terms of the supportive measures. And if it's a reasonable, not unreasonably burdensome, not punitive, non-disciplinary measure that I can take, some situations that may mean moving the student employee to a different workspace. Sometimes that may mean, well, gosh, because we have this situation and the complainant is another student employee and you both work in the same, small coffee shop on campus or whatever the case may be, I'm going to put you, respondent student employee, on paid leave. And if you can do so, fact specific under this scenario, then that's permitted.
And now to that question, we had another question that kind of builds on that, which is when you're talking about a student employee in the context you just discussed, is it the fact that the student happens to have an on-campus job, or does the complaint and conduct alleged therein have to arise within the context of the student's employee?
Yeah, I think it's a great question, and I view it as the latter. So it's a really good question. It's not just the mere fact that somebody happens to have both a student head and an employee head. We're talking about where does the alleged misconduct arise.
All right. Just one, I think we have one or two more questions. Is there anything in the preamble or in the regulations that governs whether and how advisors that we may appoint for parties that don't have them have to be trained?
I will say that I don't recall reading anything about either the frequency of or a requirement that advisors be trained, particularly because keep in mind that a student or employee respondent can pick their own advisor. And so in many cases, I think it's contemplated that these would not be individuals who we quote unquote control or maybe even have a relationship with. That said, if there was going to be a pool of advisors, for example, under that scenario, to me, it makes good sense that they be trained somehow, whether by us or we encourage, by us, I mean the university, or we encourage them to go get training from some third party as a condition of being a kind of like university panel advisor. I would think that makes good sense.
Yep. And just, I think we're up on time, but you mentioned frequency and we got a couple of questions about that. So technically the required training that you'll see in 106.45, I think it's B13, where it goes through the required trainings. The department has made clear in the preamble that they're not attaching to that an annual or some other frequency requirement on how often those individuals needed to be trained, understanding that the institution has discretion to sort of train as often as needed. That is if you want to see a little bit more about that, because we don't have a lot of time, 302.53 and 302.54 get into that concept. So with that, I think we have gone through all of the questions, but if you have any other questions, Jim's information is on the slides right now. Please remember to provide the CLE code survey information if you're looking to get CLE credit. And thank you again for joining us today. And for those of you that have been joining us over the last few weeks, we really appreciate your attention to this issue and working with us to develop some really good thought leadership on this point.
Thank you all very much. And thank you, Christina, and particularly thanks to Chris for bearing with me as I kept asking you to advance the slides. Appreciate it.